I'm Ashley Strauss-Martin, attorney for the Realtors Association in New Mexico. I'm here today to talk to you about the assignment of contract, RANM Form 2103, that was released earlier this year. I often get questions about how to transfer listings from one brokerage to another, or in the event that one property management company is transferring a residential rental agreement and a property management agreement over to another brokerage. These are two situations in which the assignment of contract could be used. At the top of the page, there's a disclaimer, and I encourage you to review this and to have your clients review this because it's very important information. It says, before entering into this assignment, please review the underlying contract to confirm that an assignment is permitted. There may be language in the contract that prohibits assignments, so you need to look for that first and foremost. Some contracts may explicitly prohibit assignments. Others may allow assignment of the contract, but only with the consent of other parties to the contract. And still others, by their nature, may not be assignable. One such contract that is by its nature non-assignable is a personal services contract, such as a listing agreement, a buyer's broker agreement, and a property management agreement. In the event the party who is to perform the personal service wishes to assign his or her obligations under the personal services contract, he or she must obtain written consent from the other party to the personal service contract prior to assigning his or her obligations under the contract. Parties wishing to assign or accept assignment of rights, obligations, duties, or benefits under any contract should consult with an attorney prior to entering into any assignment agreement. Following the disclaimer is a paragraph that identifies the assignor, who is the party assigning the contract, and the assignee, who is the party accepting the assignment. Paragraph 1 allows the parties to select the contract being assigned, and there's a list of the various agreements: the purchase agreement, property management agreement, residential rental agreement, commercial rental lease agreement, listing agreement, buyer broker agreement, lease purchase agreement, lease option agreement to purchase, right of first refusal, and other. It is noted under the respective agreements if assignment of the agreement requires the consent of all parties to the agreement. Again, personal services contracts will and others will not. For example, the residential rental agreement prohibits the tenant from assigning the contract, but allows the owner or the property manager to assign the contract. In the case where the owner or property management assigns the rental agreement, it is not necessary for the tenant to sign or agree to the assignment, though of course you want to notify the tenant of the new contact information for the new property management company. Please remember that even if the contract does not, by its nature, prohibit assignment, there may exist language in the contract that prohibits assignment. The RANM Residential Purchase Agreement is not a personal services contract. Furthermore, it does not include language that prohibits assignment. Therefore, the Residential Purchase Agreement is assignable. However, the Commercial Purchase Agreement does have language that specifically prohibits assignment without the consent of all parties to the contract. As a side note, I frequently receive questions regarding a buyer's ability to contract anonymously. For purposes of enforcing a contract, there must be a name associated with the buyer. But one way to conceal a buyer's true identity is for someone other than the actual buyer to enter into a contract and then assign his rights in the contract to the actual buyer just before or after closing. All the circumstances surrounding the particular assignment must be considered, and the buyer should consult with legal counsel to determine the best way to handle such a transaction and to learn about all the possible consequences, tax and otherwise, of purchasing in this manner. Now back to the assignment. Paragraph 4 addresses the monies paid by the assignee, again the person receiving the assignment, to the assignor, the person assigning the contract. And it's important to note that this is not a term of the assignment. This is what's called a recital or a preamble, an explanation of how the parties got to this point, which means that the provisions do not obligate the assignee to pay the assignor. As noted in the paragraph, payment has already been made per another agreement between the assignor and the assignee. Paragraph 5 is where the terms of the parties' agreement begins. A talks about the assignor's intent to assign. B talks about the assignee's intent to accept the assignment. C is very important. It deals with the assignor's liability after assignment, and you have two options in paragraph C. The first box indicates that the assignor is released from all obligations under the contract that is being assigned. If the assignee does not perform on the contract, then the assignor is sued, then the assignee agrees to indemnify and defend the assignor. The second choice is that the assignor remains obligated under the original contract if the assignee does not perform. Paragraph 6 sets forth the assignor's warranty. For example, the assigner has the right to assign the contract and the assigner is not in default of any term of the contract being assigned. Paragraph 7 prohibits subsequent assignments of the contract. without prior written consent of the parties to the contract. Paragraph 8 is very important because if there are monies being held by the assignor or other parties to the original contract, this is where the parties will describe how those monies will be handled. For example, if one property management company is taking over the management of a property from another brokerage, this is where the brokerages would describe how to handle the tenant's security deposit being held by the assignor brokerage, how it will be transferred to the new brokerage. The last provision that is noteworthy is in paragraph 9, the waiver of liability. It provides that all parties should conduct their own due diligence as to the legal sufficiency, feasibility, and consequences of the assignment, and notes that such due diligence may include speaking with their own respective attorneys. For more information, please call the RANM Legal Hotline in Albuquerque at 821-1583 or statewide at 877-699-7266, or you can email us at legalhotline@nmrealtor.com.